very exciting. It is on computer-related inventions and their profound impact on IP law. Managed by IHIPP, this session will explore the effect of CRIs on IP law, covering challenges in drafting legal frameworks in India, the US, and Europe, and recent case law AI-based inventions. First, I would like to invite our moderator, Ms. Renu Bala, who is an associate partner at SS Rana Co, a registered patent agent with 12 plus years of experience in patent prosecution in diverse domains of computer, chemical, mechanical, biological, and pharmaceutical sciences. Welcome, ma'am. Our first speaker joining her is Mr. Abhishek Sen from S. Majumdar Co, who is a patent attorney with over 19 years of experience. He specializes in software, electronics, telecommunication, and patent prosecution, including oppositions and infringement opinions, crucial for content creator IP protection. Welcome, sir. Let us call upon stage Mr. Pranay Prabhu Goankar, the founder of GIPC. He is a registered Indian patent and trademarks agent with 17 plus years of experience in IP strategy, handling 400 plus digital patent applications, leading IP teams, managing acquisitions, trademark cases, coaching, and promoting diversity in innovation. Welcome, sir. It's my pleasure to call upon stage Mr. Dhananjay Ramakrishnappa from Flexera. With 20 plus years of experience in Ericsson, Microsoft, and HackerRank, he holds US patents in computer system security. He's also the founder of Joining the Dots Foundation, where he empowers rural communities through education, sports, and environmental initiatives. We welcome you, sir. Finally, we welcome Mr. Ashok from IPR Tribe with 16 plus years of experience in patent prosecution, IP strategy, and litigation support, making him a valuable resource for content creators navigating IP rights. Let us welcome our distinguished panel members. Now I'd like to hand it over to our moderator for the session, Computer-Related Inventions, Impact on IP Law. Thank you.
Thank you so much for joining here today. Thank you. I welcome you all for this interesting session on computer-related inventions and their impact on IP law. Our today's topic is computer-related inventions. So computer software is an integral part of every hardware these days, starting from the technologies of artificial intelligence or e-commerce or online, be it online gaming or 3D technology. So the software is integrated in all the important technologies and domains today. So because keeping in mind that the software is evolving very fast, it has developed. There is a boom of computer technology and software-related inventions over past few decades. So there has been increase in filing of patent applications. For instance, in 2018-19, Patent Office received around 5,540 applications for computer-related invention, and so if we see at the data of 2022-23 of annual report by Patent Office, it increased to 20,315 applications for 2022, the year 2022. So, but if you look at the data of granted applications in 2018, it was 1,074, which increased only up to 3,718. So the question is, like, Patent Office has there should be guidelines for assessing these inventions. Although Patent Office has released CRI guidelines to help the examiners for how to evaluate these patents, and but still much more have to be done in this era area. So my question starting is like, as an inventor, so basically it starts from the very basic, from the inventor level, that what are the challenges that the inventors face while screening the inventions, how to go ahead with the computer related inventions. So my question is to Dhananjay.
Thanks, Renu. So I'm the only non-legal person in the panel, so please mind my simplicity. I might oversimplify for understanding. See, as an inventor, at least in India, so I've spent like 50% of my time in US, where the patenting culture is quite strong, and 10 years in India, so I have experience dealing with both. So I had 2 patents in US, I came to India, and I saw a few myths that had to be broken. The first thing is, engineers think patenting is rocket science. It is not. It definitely is not. So that myth has to be broken. The second myth, which is probably the most, disastrous to us, is patents are evil. Right? We are in a business. So somewhere there is this whole Robin Hood mentality that we should just spread knowledge for free. I don't think that works for businesses. I think they need to understand where their paychecks come from. So they have to protect their innovations. Then the other thing is, it's only for big corporations, because startups feel that we don't have that machinery, so we don't have that support. Let's add a lot of features and get money for the company, revenue for the company. And yeah, what else? I think I'll just take some cheat sheets that I prepared, because I don't want to forget a bit. So the other myth that I had was software cannot be patented. This is something that I've heard from so many people, so many founders. I think these people have been in the SaaS industry for so long, and they say that, oh, software cannot be patented. This is very, very common. So from a myths perspective, these myths will have to be broken, because these are not even allowing the innovator to go and think of patenting. Then there is a mindset that we have to cultivate in innovators. So first thing is, you need to be very curious. Your patent is not coming from a silo. You need to understand the entire system, the subsystems associated, and also how it is adding value to the customer. Only with that holistic understanding you are going to be able to think of an innovation. Otherwise, so this is something organizations will have to do. Make people break the silos and think a little bigger. Otherwise, they won't be able to file a lot of innovations. I worked at Microsoft for 10 years, where the culture of this whole patenting was like great. So there was a lot of, you walk by any tenured person, you would see the patenting plaques and those, we would get these small little cubes as recognition. And that was a badge of honor. To be honest, I would look at it and I would get a lot inspired that I would want it one day. To be honest, my patents came out as a result of looking at all this and getting inspired. You go and talk to these tenured people and the stories that they say, all of this. There should also be this mindset of collaboration, because my patent has 4 people in the application, right? But there are at least 40 people minimum who contributed to it, who couldn't make it to the, the list. But you really need to work with a lot of people, and that, so I remember, I can give one thing where I was working with a person who had 25 years of experience in file systems, one of the most busiest people. But the culture of Microsoft was such that he gave me at least 20 to 25 hours in my just innovation. So without his support, I wouldn't have been able to do that. So companies will have to have that culture. Then I come to all of you, right? When I basically found that I had something to be innovated, I started talking to the patent attorney at Microsoft. So that's where my whole, how do you put it? I did not have any understanding of like how this works. The way I think they helped me understand whether my idea can be patented or not, that was amazing. So even today, I remember my first conversation with my patent attorney. There was also a lot of internal support for me within Microsoft, where they would tell me, hey, this cannot be patented. So that really helps. You might have come up with an idea, but you should be okay to, and like I think you should be okay with, hey, you have put a lot of effort, but this cannot be patented, or part of this can be patented. And later, definitely all of you know, I think here, what an art it is to actually draft a patent application. Because my one-pager converted into a draft was pure bliss to watch. Even today when I read my patent document, I'm like, hey, what did I invent and like what it took to take it to the final stages. And I would like to bring in the whole small startups and medium enterprises. They really don't have the muscle that these large corporations have. So there is a lot of support system that has to be built for innovators coming from these companies. They really will have to partner with some quality firms. If they don't do that, then if you really are partnering with somebody who doesn't even value your innovation, who doesn't have experience in this whole filing, searching, all these processes, then I think it is going to take a big hit for you. I think, yeah, pretty much these were the points that I had, Renu. Thanks.
Thank you, that was really helpful. And so the role of patent attorneys in drafting and in prosecuting these applications is very important. And but there are some complexities at that, and also while they deal with the patent office and how they get granted and the procedural aspects. So my question is to Abhishek, that based on your experience, you have profound experience as a patent attorney. So how has the Indian Patent Office adapted to changing the technology trend, and how legal precedents have changed the understanding of CRI inventions? So what are the common complexities or difficulties, challenges in the prosecution of the patent applications?
Yeah, good morning everyone, and I will just start with where DJ has left. So he said that software patents, software inventions are not patentable. So if you ask me, my answer would be both yes and no. So why yes? Like, as we can see at present, the Indian Patent Office, they are granting software applications which are having support of hardware integration. So having said that, if we go back to the guidelines of 2015 CRA guidelines, so there was a particular problem with the guideline where the guideline said that you should have a novel hardware feature when you are claiming a CRA. So that was, you can say, a drop of poison in the guideline. And in view of that, there were several applications which were refused by the Indian Patent Office. And there were several deliberations on that. And we had a few meetings with the Controller General, with the Ministry, because a lot of stakeholders were also complaining about that guideline. And after that, if we go to 2017, where we have the final guideline for the CRI, where the Patent Office, they remove this hardware, novel hardware requirement. And if you see the history from then, the number of applications which have been granted by the Indian Patent Office in the software domain, now that has drastically increased. Now the question is that if we have a software invention, then why there is a requirement of hardware integration? Is software not patentable? Software is also a technical feature. You have a software program, you have algorithms. So if I am integrating a software feature, say for example a program or an algorithm with a hardware, of course that will be patentable, but again, if I am trying to claim it in its standalone manner, will the Patent Office grant such cases? Now here there is a question that when I am dealing with software program, whether it's a technical feature. So when I am integrating a software program or an algorithm and it is able to show some technical effect in the invention, the Patent Office would grant a patent. And that's what several judgments of the Indian courts say. For example, if we see Ferrar-Delany, if we see the Microsoft case, and even if we see the ComVivo case, the recent cases, where the Honorable Court has said that you need to show technical effect. But again, technical effect cannot be the sole criteria or the consideration for patentability. So when you have a technical effect, you also have to show that your document, that is the patent specification in its entirety, it has proper hardware and the integration of the hardware with the software, which is beyond the normal interaction of a software. So if it is below the normal interaction, then it will be considered as an abstract. If we rely on the Alice Corp versus CLS case in US, you will find the same findings by the court, where they have said that you should have some hardware support in the complete specification, otherwise it will be considered as a software program. So the main consideration when we are drafting the patent application is that we, as patent attorney, we have to see that whether our patent specification is properly supported with the limitations of the hardware for the software to be implemented. So we should have the hardware means described in the patent specification. If we refer to the judgments given by the Delhi High Court, now there they have said that the system plus method claims would be patentable. So when we draft the patent application, we should be very careful that we are claiming the system along with its method so that it gives you a broader coverage. So when it's a normal system, it would have more of the hardware feature in it. And if you claim a process, it would be having the process feature. But if you claim the system and the method in conjunction, then you will be able to support it properly, and rather you will have a broader scope of protection. That's what the ComRevo has said. Also, even if you go to the Microsoft case, then you will find that the same findings have been given by the court. Now, the other aspect is that when we are claiming CRI, for example, is it necessary that for all CRI application would you have hardware in that? Or rather, hardware would define the technical feature? Now there are several questions which come up when the inventor is trying to disclose his invention to the attorneys. Rather, at the first instance, the inventors wouldn't like to disclose everything, maybe for his own understanding of the patent, or he doesn't want to disclose all the features. But as a patent attorney and as a best practice, what we would suggest that when we prepare a patent application, we should be given all the information about the invention and how the invention has been practically applied. Because when we are talking about the technical effect, so technical effect is more about the technical application of the software program in a hardware. So there is a, you can say, is a marriage between the software and the hardware. The other question, Renu, you asked me about the adaptation of the Indian Patent Office. So I would say that, say about for the last 5 to 6 years, what we have observed that the Indian Patent Office has drastically improved disposal of the applications, because if we consider the lifetime of a software patent or a patent which relates to electronics and telecommunication, the lifetime would be about 3 to 4 years, not more than that. So initially it used to take about 6 to 7 years for a patent to be granted, and when the patent used to get granted, then that particular invention became obsolete. So that would have made no sense for the applicants. So Indian Patent Office, they have recruited many examiners, and also the senior examiners have been promoted to the post of controllers who are helping in disposing of the applications. And with respect to the search, I would like to say now the Patent Office has recently launched a program for automated searching, again with the help of AI, where it will help its examiner to do a prior search, and which will mostly, I would say, will be relevant to the patent application. But what we have observed over the years, say about for 60 to 70% of cases, the prior documents which have been cited by the Indian Patent Office, now those are not very relevant to the invention. So in that aspect, it has improved a lot. And again, the system has been digitized. It has been made more transparent to all the applicants, so you can access the published applications in a very, I would say, easier way than before. And insofar as the examination part is concerned, most of the things are happening online. Now the cases are heard online on a virtual platform. So it has well adapted itself as per the development in the technology. That's all.
Thank you, that was quite insightful. So my next question is to Pranay. So what do you think, how patent office or how regarding the prosecution of AI inventions, and what is the position you think in foreign jurisdiction vis-a-vis Indian prosecution system?
So, first of all, simplifying is very important in this fuzzy world. I think a lot of speakers or a lot of participants are looking for, okay, how can I understand it better? I already know it. So, there are various stakeholders, whatever invention it is, the inventors who create it, they don't want to worry about what exactly I have to put in the patent application. They don't, this is my invention, I'm proud of it. Second is either the IP attorney or IP professional in the corporate sector from a company. Third is the patent agent, and fourth is the patent office, then comes the court and other stuff. So each one has a different viewpoint. I think aligning this viewpoint is very important. I want to start at a very high level on purpose. When we come from the software patenting, and then comes the AI. And we are also talking about AI-generated inventions. I'm just raising certain points. AI-generated inventions, and now there is also AI can draft patents. Maybe another 5 years, AI can grant patents. That may happen. So please do not get confused between what is happening in the pipeline. Understand that, okay, each player has still a role to play. And that is where we need to see that, okay, when we talk about software, now, when we are marrying the software and hardware, I think the marriage itself is very important, right? Whether it's new, old, is a different topic. Now, my perspective on, we are bringing up another new term, AI. AI-based invention, AI-related inventions, AI this, AI that, right? But what is that AI? If you even Google it, it will say that AI is mainly also a set of algorithmic instructions run on a computer. Maybe it is modeled, and then the model is trained on to solve a specific problem with specific accuracy. But we need to also understand that when we are talking about AI, it is one type, one category under the software patent. And then the application comes into picture. So when we are talking about positioning, so protection of software can be sought. You have to ask yourself, yes, no, the same guidelines will apply to AI. Now, whether you want to use the word AI in the claim 1 or claim 5 does not matter. Is your invention patentable is a question you have to start with. So simplify things. Do not try to escalate based on a lot of noise around you. Secondly, what I observed in a decade across the different jurisdictions where I got to work with myself and with other attorneys across the globe is the US started saying that, okay, I want to see significantly more. What you are claiming, non-obvious, obvious, abstract, right? I want to see significantly. Is it more than the mere marriage between the hardware and the software. That is, now AI is a part of that software. So just when I say software, always see that AI also is included. Then you need to show that there is some synergy that creates some kind of a technical improvement beyond just saying these are 4 steps and I'm using processor or memory and other things, whatever you call system apparatus. Different people use different terms. That is first important to understand that am I really worth getting this? So significantly more. What is that wonder that is happening? Wow effect was already there 20 years or more. So we are just changing the term every 5 years, but I think understanding that the regime is still on the track. Second aspect, and when it comes to the European, they say that technical effect. I want to see you are solving a technical problem using a technical solution, and then that has a technical character. When you put a processing unit, they say you have a technical character. But then they say I want to see the technical effect that is being generated by the solution. It is not just the physical interaction. Running a code on a computer does not mean that there will be a technical effect. There has to be something more. If I want to refer to one of the case laws, which is referred to the Enlarged Board of Appeals, was the simulation of the pedestrian movements. So when they are designing a city, they were trying to simulate, saying that when the pedestrians will cross, how many will cross, and the car movement, vehicle movement, should we have a sky walkover and all those stuff. So it was held that mere understanding that how many people will pass and doing it using simulation, that's a complete, like a software running and saying that even the game does that. Games when you play, they also do a lot of things using software based on the user input. But then it's like simply having a computer to run a software is not enough. What is it trying to deliver? How it is going to have an effect which is causing that computer to be considered as a more better machine, usable machine by the consumers. Then, so you have to see the end effect. Technical effect does not confuse what is the definition where it is. Is there an end effect which is having more better technical advancement than the prior art? Sometimes it is called some of the people practicing in the European jurisdiction is called additional technical effect. That compared to the prior art, when you compare the prior art with the invention, there is an additional technical effect you have to do, and then that is not obvious to the person skilled in the art to solve it or arrive at it by combining various things. So that is Euro. Then comes to India. So we are good at criticizing, but the thing is that there is a technical advancement people have been talking about. Now the courts have started, they like the term technical effect. But if you try to see that, technical, they have been saying that inventive step is all about technical advancement. Economic significance also in certain cases, but technical advancement. So the question across the board from the inventor to the patent office is that why should this invention should not get a patent? See, our culture has become is that invention is the patent. Beyond prior art, do you ask yourself or the inventor, why should not you get the patent? When you talk to the inventors, stress upon, invest more time when you're talking to the inventors rather than saying, drafting is an issue and examination is an issue. No, the issue starts with your interactions with the inventors are not very, very much clear. You are not able to get the data and you are jumping the gun by saying, I will draft it, don't worry, you give me this and I'll draft it. And once examiner raises the question, then there is a problem. So now I come into the AI. Specifically, when you are talking about AI, now what kind of information you should look at? Just having a trained AI model, whatever kind it is, LLM or generative AI, Gen AI, machine learning, general artificial intelligence, different names. Yes, definitely it matters to an engineer, right? But not the patent office. So we need to see that, and that was when I was working with my previous employer, we have various discussions and beautiful perspective came up. Said that, do not focus on the AI, it is still a code. Focus on what you are feeding, pre-processing. Focus on post-processing. Once you get that some kind of a fuzzy output, how you convert into something that is usable by the computer and then do something. So the post-processing and pre-processing have been, recently we had a case with the Indian Patent Office, exact prior art, but the post-processing is different, pre-processing is different, still it is invented. So you need to also try to ask that, okay, what are you feeding to the inventor? The AI model. You have to ask the inventor what you are feeding to the AI model, the trained AI model. Rather we focus more on training the AI model, right? So that's not in material unless it is a self-learning, real-time self-learning model. If the model is trained, it will be fit into your car or wherever it is, and it will try to gather the data, it will be fed, and it has to function, right? ADAS systems has to function, for example, ADAS. So I'm just saying, so this is where we need to see that how we are converting a normal data into a data that can be understood by a trained AI model, and that will be the inventiveness. Because if I feed just an image, pixel format, whatever a resolution and whatever using a histogram data and other stuff, it will not work. It has to be fed in a specific format. Secondly, it has to be also the proposed processing. If it says that, okay, is there when you are driving a car, there is an AI and it says, okay, there is a pedestrian or not. Yes, no, but the thing is that, okay, the AI will give the probability. I see something, but it is, so how do you convert it into? So these are two magic points you have to always stress upon when you are drafting, and have to be brought into the claims in order to show the technical effect that, okay, my AI model is different, my invention is different from the others because I am doing it in a different processing way than the others. That's the logic. So this is something which considerations has to be there. First mover advantage I always like. People should not focus on what kind of model is used in the claim, then you are lost because the models keep evolving, different types of models keep coming. You have to see that, okay, will this sustain for next 10 years, the claim? Even if the AI model, tomorrow it is called Gen AI, there's something, after that something, it should sustain. The claim should sustain throughout next 10 years, then only it is beneficial. So that also you need to keep in mind by saying, okay, do not stress too much on which AI model into the claim itself, but into the description. Yeah. So that is some of the points that what I would like to share with the participants here. So thank you very much.
Thank you. That was quite insightful. So my next question is to Ashok. How patent portfolio help the industries, and what are their perspective while handling CRI inventions?
Good morning. So, as we speak portfolio, I mean, and how do you see portfolio in layman language? I mean, for me, portfolio, I mean, I've been an in-house counsel for 16 years for different automotive companies. So my position compared to others is better because automotives have some of the other hardware involved. So it's easy for you to speak of the technical effect. So what is a portfolio? I've been with Tata Ford, and my recent one was Ola, and after that I quit. So is the same criteria that I choose at Tata, is it the same thing that worked for us at Ola? No. So when we speak about portfolio building patents and all, it firstly goes to the strategy that you're working on. How do you build your strategy? I mean, portfolio is nothing but bunch of patents that are going to come either to do your business or to stop your competitors. How are you going to build? So when we look at the strategy part, when we build portfolio, any mechanical company per se in general, there are different levels in which you measure. You can't have the same thing. For a mechanical engineering thing, the technology lifespan is good 20 years or 15 years. If it is electronics industry, it's a different, the shelf life is different. For a pharma, the shelf life is different. So, when we decide on the policy, what to file, what not to file, during my initial days of career, the main things that are taken into consideration were, is it easy to detect if someone copies? Otherwise, it doesn't make any sense in filing patents. And what's the scope of the claim? Is it a picture claim, or are you getting, what's the scope of the claim? How many words you're putting into the claims? Are you able to get a claim with lesser number of words, which otherwise means is it broad enough? with automotives being evolving from mechanical to mechatronics, is it the same criteria that we adopted in building the portfolio? No. So initially it was just about what you call detectability and scope of the claim. As we went along, the lifespan of the patent came into picture. So there is a person, who said, when we were working on the budgeting part, see portfolio, any patent, any team, when you have a portfolio, it's going to cost you money. So any patent, if it is not making any financial sense, is, you're wasting money. So how do you convince your leadership team on spending some money on the patent? So for every patent, what we did was, every patent has a lifespan, right? In filing, prosecution, there are different costs that come in. So we bracketed that into different stages of life. And also we asked the engineering team, whenever they come up with inventions, when an engineer comes, for him, all these budgetary issues doesn't play. For him, it's an invention and it has to be protected. But for an IP person, you have to budget that and give a convincing answer on why you are filing it. It's not just patentability that says go file a patent. It has to be a reason. So we had budgeted, we had divided the cost associated with each patent in different layers, and we had asked the engineering team to come up and provide us with an ROI. Say if they say that the shelf life of the patent is going to be 3 years or 4 years, if we are going until the prosecution stage in those 3 years, so what is going to be the ROI that we would make out of it? If not ROI, are we able to, we either ask in terms of ROI if it is going into our product, if it is not going into our product, if it is just for the purpose of, stopping competitors from entering into market, in that way, we would ask, what's the scope of the claim, how effective is it going to be in doing that? Mere improvements, see, software patents per se, like I said, me coming from a mechanical background, it's very easy to, pitch the technical effect. However, when you write, if you are planning to write a method claim for a software-related invention, any invention you write, it's mostly going to look like an abstract patent. If you take out all the hardware and the technical effect that's being done. So we had the practice of asking questions, what's going to be the impact, what's going to be the ROIs, how impactful is it going to be in stopping. So these things we had taken into consideration when building a portfolio of patents, and then based on that we build portfolio. See, in a regular way, if one patent goes out of, if there is one technology that goes out of market, as in if the shelf life is done, it's only that patent or a couple of patents related to that you got to discontinue. But does it apply the same in CRI? No, I believe there are a whole lot of patents that goes out of technology along with the main patent that you have. So we used to audit them every year to see what are the patents that are really relevant and what to be discontinued. So this was with the bigger industries. Now we started working with smaller startups and MSMEs. So portfolio is strength. Portfolio is something that gives you strength. It's your army to fight with your competitors. So when we work with startups and MSMEs, it's not the same way they look at it. There are many budget constraints, even though Indian Patent Office allows them to file expedited examination and all. From an MSME and a startup point of view, it's still burning your pockets. So you again got to be very careful about what to file, what not to file. So everything comes back to your strategy when you build portfolio and how you position yourself. So there is no specific answer that this works this way. So it should be industry specific where you decide, factor in what are the different things that you should take into consideration. Yeah. Thank you.
Thank you so much. So that's from a perspective of the industry and how they should filter out the inventions. And thank you so much for that. So there is a quick question. Keeping in mind that few minutes are left only, so a brief takeaway from each of the panelists, like what is their takeaway, starting from Abhishek. Okay.
See, this CRI, if we see the guidelines now, from then we have been discussing about this. It's almost more than 10 years, or a decade. But if we see the guidelines, now guidelines is still not very clear to many. Like if we see the latest guideline which we have, we don't have any examples that would help the examiners and also the inventors so that they are aware that what exactly is patentable under CRI. The problem is that when you ask to an inventor that what is the technical feature, what is the effect that feature is producing in a particular system, you may not get a proper answer to that. But again, if at all you are getting a good answer from the inventor about the technical effect or the feature, the next problem is that when you are prosecuting the application before the patent office, so when you do not have a proper guideline is in place which is lacking lacking proper examples, so prosecuting patent applications would be difficult. Having said that, now there are many applications which have been granted, and we, thanks to the Indian courts, from where you have several judgments and which are very clear about the requirement of the technical effect, and which also says that the guidelines cannot be binding for examination. So we need to relook into the guidelines of the patent office.
So very short addition or the brief takeaway or plus to that was, I think we need not worry about too much about the AI generated inventions. We are talking about human generated AI inventions, but AI generated inventions, because I think slowly the law will evolve that a human should own the IP and the human should be the inventor, and humans are training that AI model which generates the invention. So globally, when I'm speaking to the leaders and experts, the common message that comes across is, when the AI generated that invention, who has deployed that AI? The inventor relationship or the ownership that is created. Because of the lot of legal nuances, and we should keep it at that and see that how it evolves in the next decade. And that is where it is so, because I thought of touching upon this because the impact on IP law. So we, as I said, okay, comparison across the different jurisdictions, we talk about significantly more technical effect or technical advancement, more or less the same treatment. And I think that's a fantastic that happened in the last decade, basically through the case laws. So thank you very much.
Yeah, I have two takeaways. One is understanding innovator as a persona. I think please invest a lot of time in understanding this inventor. I'm quite amazed by what Ashok was talking. So now I do yearly planning, multi-year planning for the organization. I'm going to take this patent portfolio very deeply into my planning process.
Thank you. So my understanding of portfolio is, again, to conclude, computer-related invention, people who file patents are still being conservative. So for that to get away, means, and if you see Japan, the expedited examination for that reason, they provide expedited examination like India to MSMEs education institutions and all. Apart from that, they also provide expedited examination for patents related to green technology. Probably, we should also start looking at technologies and the shelf life, and accordingly, propose this to the government, so that CRI related inventions, people are not going to be conservative in terms of filing.
Thank you so much to the panelists for their insightful and a very elaborate explanation. So to conclude, so we have from the discussion on the inventor side, on the industry side, so we understand that it is very important to screen the inventions relating to CRI invention and see how technical effect increases the processability of the hardware, and those we have to screen from the computer program per se, which are actually non-patentable as per the laws. So the hardware integration and how it is enhancing the hardware is very important, and at the same time from the patent office or the attorney perspective, so we need more examples. So we are thankful to the judgments passed by the honorable courts, but at the same time we need more examples in the CRI guidelines to understand what technical effect is and how do you define, because of the complexity of
different software related inventions, be in the AI related field or be in the online gaming part or in other sectors, because software is integrated in each and every hardware, starting from all the machineries. Like now everything is computer enabled, so that's how so keeping in mind the complexities of a computer related invention, there are more clarity is required from the patent office from to understand, to process these inventions, and at the same time more awareness is required on the side of inventors, like how they should screen and how they should visualize. Like they should not go ahead with the computer programs per se, but anything that is enhancing this hardware. So that is so thank you everyone for the wonderful session, and thank you everyone for bearing with us. Thank you.
Thank you.
Thank you for that fantastic panel discussion on computer-related inventions and its impact on intellectual property law. I'd like to request Ms. Renu Bala to kindly felicitate our panel members, starting off with Mr. Abhishek Sen from S. Majumdar and Company. Next, Mr. Pranay Prabhu Govankar, founder of GIPC. Now, Mr. Dhananjay Ramakrishnappa from Flexera. And finally, Mr. Ashok from IPR Tribe. We have a token of appreciation for our moderator, Ms. Renu Bala. I'd like to request all panel members to please pose for a group photo. Thank you very much.